recording it? Thank you so much, Anne.
Absolutely. All right. Thanks for coming over the noon hour on a Friday, everybody. It's really nice to see everyone, even virtually. I'm going to share my screen with you. Just 1 second. All right. So like she said, I am the special immigrant juvenile attorney for Immigrant Legal Center here in Omaha. I kind of geared this presentation towards all service providers. So some of it I've geared towards the attorneys that will be representing youth in the court system, or any service provider that is involved with youth in the court system, as well as I think generally I've assumed that you know very little about immigration law. So if you do know a lot about immigration law, this might be a little review for you. I'm going to try and keep this a tight 30, but it is a lot of information. So if I go over, I apologize. With that being said, please feel free to put in the chat questions whenever you have them, and I'll try to check it periodically to make sure I'm answering those questions as we go. So our agenda today, like I said, we're going to be talking about what Immigrant Legal Center does for the Nebraska community, first and foremost, and how you can direct undocumented youth or undocumented undocumented people in our community towards us, as well as a brief overview of immigration law. When I say brief, I mean very brief. Immigration law, I'm sure most of you know, is pretty complicated, and I just want to give us a good basis so that we have an idea of what we're talking about in the next few slides after that. Then we'll talk about how you can serve undocumented youth and the specific considerations that we have for undocumented youth that are involved in the court system specifically, and criminal activity for those youth, and how that might affect their immigration journey. And finally, I'll wrap up with a quick overview of relief options that are available for youth. The Immigrant Legal Center is a nonprofit organization based in Omaha, but has offices all over Nebraska. We just recently opened our Lincoln office, which is exciting for all of us. And we welcome immigrants into our community by providing high quality immigration legal services, education, and advocacy. We do serve populations at or below 150% of the federal poverty guidelines primarily. And we provide completely free services for that reason.
Not in Lincoln that I am aware of. Not
the ILC problem.
You know, there's an immigration one. And
all right. ILC programs primarily focus on asylum. Our clinic program, which includes naturalization and other relief options. Our family-based program, which I would say most of our a lot of our practice revolves around impact litigation, and the UT and VAWA programs, which are the more humanitarian. I'll do a plug here for NELA, and there'll be another one at the end. The Nebraska Immigrant Legal Assistance Hotline is the main contact for new clients for Immigrant Legal Center. But the great thing about NELA is that they will refer clients to many different organizations around the Nebraska community. So if for whatever reason the person calling does not qualify for services, or we don't provide the services at Immigrant Legal Center that they would need, NELA has some other options available. I have put down the phone number and the website for NELA. And generally when we have a client that we have not had any interaction with prior to this, our first referral is going to be to NELA no matter what. That's where our wait list comes from. And although our wait lists have been getting shorter in the past couple of years as we retain more attorneys, we do still have a wait list for services. This is our contract information that I will include at the end of the presentation as well. And here we have the brief overview of immigration law. Once again, I will emphasize brief. Here is just a little picture at the U.S. immigration system. It looks complicated with the arrows. It looks a little messy, and that's by design. It is complicated to practice in the U.S. immigration system. It's difficult for us as educated lawyers to navigate the system. So you can only imagine how difficult it is for anyone who is unrepresented. And because, as you can see, most of immigration law is under the executive branch, and there is no constitutional right to have an attorney represent you for the majority of the practice. In the last 3 years, approximately 1,400 people have been processed by the Omaha Immigration Court, and 65% of those 1,300 were unrepresented. We have had an influx in the past few years of unaccompanied minors. So there was a huge amount of minors that were in front of an immigration judge with no representation. And you can only imagine how hard that could have been for them. One way that the immigration system has tried to address this huge amount of unrepresented individuals in the immigration system is that they allow Department of Justice representatives to help immigrants navigate the system. These are non-attorneys who go through an accreditation program that are able to authorize and able to help out immigrants navigate through the system. They cannot represent them in front of an immigration judge, but they can help them in a lot of other instances. The main categories of immigration relief in the system: family-based, humanitarian, employment-based, and diversity program. As you can see here, ILC mostly deals with family-based immigration and humanitarian relief. I've put this here as a little glossary of law labels, immigration law labels, as an indication of the different types of individuals that could be involved in the immigration system. Citizens or nationals are, citizens are by birth, and nationals are obtained citizenship by status. Non-citizens can also be referred to by immigration authorities as aliens. Non-immigrants are those who enter the country with temporary visas. They enter for a temporary purpose: work, study, visiting, receiving medical care. Immigrants are people who are sponsored for entry by a family member or employer, but have not yet finished the journey. And refugees and asylees are refugees and asylees. We'll talk a little bit more about the definition of those later on. I've also made a note here that one of our parts of our practice that we've tried to be really conscientious about is not referring to any person as illegal. You'll hear me most of this presentation referring to youth as undocumented or as undocumented immigrants for that reason. I would also make a note here that when serving individuals in the undocumented community, you're going to run into a lot of wariness about not only authority figures like police and judges, but also wariness for attorneys. They communicate a lot within their communities about the types of relief that are available to them and the impact of their actions on that relief. So they come armed with a lot of information and a lot of really great questions. They're also a little hesitant to give the entire story sometimes, and it's understandable why, because they don't want any misstep to impact their life-altering immigration journey. So I do just make that as a practical note to always be aware that, and to create a relationship of trust with your clients so that you are getting the full story and you are able to be prepared in all instances. Real quick, just an explanation of these two terms, inadmissibility and deportability. So this is a lot of the time, or a lot of discussions of immigration use the term deportability to include both of these terms. But what I'll be talking about today mostly is inadmissibility. So undocumented immigrants in the United States are are subject to the grounds of inadmissibility if they entered the United States without inspection, meaning they entered without a visa, they entered without being or speaking to Customs and Border Patrol, they entered without being inspected. So this can include all of the people listed here and some people who are listed as paroled into the country. It's kind of dependent on their status, as well as some of the employees that are allowed to enter into the United States. Generally, most people will fall into the category of EWI is what we call it, referred to it as EWI. You see that on the first bullet point under subject to inadmissibility. Those that are subject to deportability, for the most part of what we'll be talking about, are going to be those that entered under a valid visa and then the visa lapsed. So they were admitted, they were lawfully admitted and were inspected, but overstayed their visa or failed to renew their visa. And that does change the analysis a little bit, but like I said, mostly what we'll be talking about is those that are subject to inadmissibility. And I will be referring to some of the grounds of inadmissibility and deportability as we go on. So firstly, I'd like to start with talking about what undocumented means. An undocumented immigrant is a person who lacks lawful status granted by federal authorities. So like I just discussed, a youth can enter through a port of entry with a valid visa, and then the visa can lapse and they fall out of status. And that is what we just discussed under the grounds of deportability. And a youth can enter in the US without inspection at a border or port of entry. Or they could enter with an invalid visa, and that is entered without inspection and what we just discussed as subject to the grounds of inadmissibility. First and foremost, when serving undocumented youths, the best piece of advice is that any contact with law enforcement should be a minimum. In a perfect world, this would be where we would stop, but since we are talking about what happens when they do, interact with law enforcement, then we'll keep talking. One important factor in Nebraska law practice is that our age of majority is 19. I'm sure most of you know this. However, 18 USC 55031 defines juvenile delinquency as a finding made by a juvenile court of a violation of law prior to a youth's 18th birthday. So while the age of majority in Nebraska can benefit some youth for some immigration relief options, which we'll talk about later, it does cause some issues when we're talking about juvenile court and delinquency proceedings for 19-year-olds because they are still under the age, or they are still under the age of majority, but they are the age of 18, which means that they are adults for the purposes of federal law. And because immigration is federal law, it can get a little complicated. So we'll talk a little bit about juvenile court practice and status determination versus a conviction. Juvenile delinquency is an act that would be a crime if committed by an adult. So what you'll see here are some terms, the terms in juvenile court versus the terms in adult court. And I put these here because I think it's very important to get our language straight when discussing this, especially in immigration context, because we want to make it clear at every point we can that a youth was adjudicated, not convicted, and they were the subject of a juvenile court and not adult court, because that has some really important implications for them, which include being subject to the grounds of inadmissibility due to certain crimes. And some of those grounds are based upon convictions. So if there is a status determination and not a conviction, then they are not subject to those grounds. And that's extremely important because those grounds are mandatory bars to their citizenship, and they will not be able to seek legal status in the United States and will eventually be sent back to their home country. So I have cited here where immigration law has stated that juvenile delinquency is not a conviction for immigration purposes. So on that note, it's really important that if you are representing any youth for charged crimes, that you make sure that you keep them in juvenile court as much as you can. Just as a little picture, I think that service providers in Nebraska do a really good job of this. In 2019, 204 youth cases were prosecuted in the Nebraska adult courts, which was down from almost 2,000 in 2013. So of the 204 cases, 30% were traffic cases, 37 were misdemeanors, and 32% were felony. For the purpose of immigration law, traffic offenses generally have very little impact. Speeding, failure to stop at a stop sign. However, traffic offenses that involve drugs or alcohol are another question altogether. The data also shared that motions to transfer from juvenile court to adult court were requested in 60 cases and granted in 9. And then adult court had 117 motions to transfer to juvenile court, and 96 cases were transferred. So like I said, I do think that Nebraska attorneys are good at attempting to keep juveniles in juvenile court. And I would just reiterate how important that is for undocumented youths to stay in juvenile court to minimize the impact of their issues with the law. I would also make a note here that it's important for us and for you as juvenile justice officials and for us as service providers to hold officials accountable. I think the most important aspect of that would be to protect the use by limiting referrals to immigration services, limiting information given to immigration services. So you can see here the site that I've included that officials in juvenile court are under the obligations of 43/2001-08 that they cannot give out information about their case to anyone that is not listed in that site, in that statute, which is law enforcement agencies, but law enforcement agencies only when the child consents or when the judge orders it. So I think it's very important that we remember that reporting the status of a youth that is involved in juvenile court is generally going to go against this statute. Here I've listed the consequences of interaction with law enforcement. So this is the consequences of youth interacting. The first consequence and the most serious is youth get charged as an adult and they sustain a criminal conviction. These criminal convictions generally will be mandatory bars to their immigration relief, and you can see why that would be the most serious of these 4. The next is youth are adjudicated as delinquent in juvenile proceedings. Here, there are still some conduct-based removal grounds that they will be subject to or could be subject to, and we'll discuss that next. But it is not a mandatory bar in the same way that convictions would be. The third consequence would be documentation of the youth conducts, and this documentation could then be used in their immigration journey later on. It could be accessed by USCIS, which is United States. I'm just blanked on what that acronym stands for because I've used it so much. But that's how we refer to immigration services. And then, or it can be used at the IJ level in front of the immigration judge. Lastly, and still very serious, the interaction with law enforcement could trigger immigration enforcement. So it could trigger a referral to immigration services, to ICE, that puts a youth in the system who otherwise was not in the system. I make a note here specifically about the resource officers in school. In general, I would say, I would actually just share a story that I heard yesterday in a webinar. A youth was involved in school in a fight with another student that was referring to them with racial slurs. And this youth, while the school did not automatically get involved in this fight, this youth did admit that he was a part of the fight, and he went to the authorities at school as he was requested to do. And when he went to the authorities at school, he got involved with the the resource officer at school, who then referred him to ICE. He was detained and was in a detention center for 2 years, and he missed out on 2 scholarship opportunities and multiple admittances to colleges because of that. So I would caution all interaction with law enforcement for that reason. So now we'll talk a little bit about conviction-based removal grounds. This is if convicted in an adult court, and generally the mandatory bars are for those 3 crimes listed here: murder, torture, and drugs. I think for our purposes, drugs are the most important. I do make note of crimes involving moral turpitude. This is a term used in immigration that refers to depraved or immoral acts or violation of the basic duties owed to your fellow man. This definition comes in the context of naturalization. That's pretty far down the immigration journey when you are applying to become a citizen by obtaining that status. And crimes involving moral turpitude do require an admission or conviction. So we'll talk a little bit about admissions in just a sec, and the impact that admissions can have. The Board of Immigration Appeals has held that sale and giving away a controlled substance is a crime involving moral turpitude. But we're going to talk next about the impact of marijuana and how the special considerations of marijuana, as it has been legalized at the state levels, impact that. Here I have a chart of the criminal grounds of inadmissibility. So here are the consequences of a youth being charged with a conviction in adult court. I won't read it all, and I'll allow you to read some of it. I think I'll point out some of the most important ones. The moral turpitude is one that we just spoke about, and controlled substances and violation of laws relating to controlled substances is probably the most important, as well as the reason to believe under drug trafficking. Those two we'll talk about in the context of marijuana next. However, the more important one I would say is the reason to believe for drug trafficking. It's a very undefined standard reason to believe. So the person making the determination is usually the immigration official, and there is not a lot of evidence needed in order for them to make this reason to believe determination. So I think that is the most important to be aware of. Other ones, prostitution, I think, is one that's really important, as well as human trafficking. And we'll talk about the issues with drugs now, marijuana issues. As I've stated here, there are 36 states in the District of Columbia who have legalized medical marijuana, and 18 of those have legalized recreational marijuana. You can see there that I have some advice for all use, that they should not possess marijuana. If they feel that they need marijuana medically, they should not live in Nebraska, obviously, for obvious reasons. And they should never carry marijuana or any marijuana related paraphernalia. There are some who give advice to not even have marijuana related references on your clothes, no stickers, no buttons, all accessories that involve marijuana are not great for any youth. I will state here, I will make a point here that any conviction relating to marijuana can trigger deportability and inadmissibility under the controlled substance ground. I would also make a point here that that's true with any interaction with marijuana whatsoever, any evidence that there has ever been interaction with marijuana, especially in Nebraska, a state like Nebraska, because at the federal level, marijuana is still listed on the federal drug schedule. And even if you do live in a state, which obviously it's not the case in Nebraska, but even if you did or do live in a state where marijuana was legalized, they still will run into issues with that at the immigration level because it is federally not legal. So I did mention earlier about admissions absent a conviction. I've cited here to the INA statute that a non-citizen who formally admits to a crime involving moral turpitude or an offense related to controlled substances is inadmissible even absent a conviction. This is important for our practice because this happens quite a bit at the USCIS level where they will ask youth to, or ask the immigrant whether they have ever committed a crime, whether they have ever done anything that would could have been conceived as a crime. They make the question broad on purpose because they want to easily encompass all issues. And an admission at this level with an immigration authority, it will generally include the immigration authority reading the statute of the crime that they would be admitting to, and asking the immigrant whether they admit to that crime as it was just read. And I think it's really important to advise all undocumented individuals that admissions in interviews with immigration officials should be avoided at all costs. I obviously made a note here that a person who admits conduct while a minor that comprises the essential elements of a crime is generally not inadmissible under this ground. So if a youth is in an immigration interview and is asked whether they have committed a crime and has read the crime from the statute and admits to it and signs that they have admitted and voluntarily admitted to it, if that conduct was while they were a minor, it generally will not trigger the inadmissibility ground under a conviction. However, it does go towards conduct-based inadmissibility grounds, which we'll talk about now. Inadmissibility and deportability grounds can be triggered by conduct alone, even absent a conviction. And this goes towards some discretionary decisions that are made at the immigration level with immigration officers as well as immigration judges. Here you can see a chart, delinquency disposition and their immigration penalties. As I've been saying, a conviction at the adult court level is a mandatory bar, and an adjudication at the delinquency level is a conduct-based bar. So drug trafficking can trigger the bars or inadmissibility, as well as drug abuse and addiction, as we just talked about. I think the one that's slightly more problematic is the behavior showing a physical or mental condition that poses a current threat or self to others. And generally here, this is where immigration might talk about some mental health issues, or if there's ever been an attempt at suicide, or if there's ever been maybe harm done to anyone else due to a youth's actions. As you can see, I've stated that waivers are available. These are very specific to the situation, but I just wanted to state that waivers are available so that you know that further research is required for those waivers. And also you can find it with the site to the INA. I've also included prostitution and violation of no contact orders here. As you can see, I've made a distinction between inadmissibility and deportability. So this is where the distinction of how a youth entered the United States can be important. False claim to U.S. citizenship is also very, very important. You'll see later that's one of the more important advice that you can give to your youth clients is that they should not be working without authorization in the United States. And generally where false claims to U.S. citizens become most problematic is when they have claimed a U.S. citizen's name or social security number in order to get a job. Obviously, you want to caution very highly against that. So even without the admission to USCIS, if there's a determination that the conduct of the admitted crime could have led to charging the minor with adult criminal proceedings, then the immigration authorities can still make a determination of inadmissibility or deportability. And this is where the skills come into play as a lawyer of arguing whether that specific admission that they are determining would have been charged in adult criminal proceedings, or could have been charged in adult criminal proceedings, would not have been. And this would require a look into the state law and research into cases that have been similar to that. So quickly, we're going to go through some immigration relief available to youth. Like I said, I'm on the special immigrant status team in juvenile status team at ILC, and we have recently kind of beefed up this team because we have a lot of undocumented minors in Nebraska, and a lot of unaccompanied children who have come to Nebraska. Special immigrant juvenile status protects abused, abandoned, and or neglected children involved in state court proceedings by allowing them to apply for permanent resident status. In order to be eligible for special immigrant juvenile status, you have to be under 21, unmarried, present in the United States, and subject to a state court order. That state court order has to have specific findings, and those findings are that they have been abused, abandoned, and or neglected by one or both of their parents. Reunification with one of those parents is not viable, and return to their country of last habitual resident is not in their best interest. And I would make a note here when speaking with with youth about this form of relief that either parent, regardless of whether they are listed in those special findings, cannot benefit from the immigration status of a child who received it through SIJS. So generally there are family-based relief available, which we'll talk about in just a little bit. And that relief is usually done by a US citizen or legal permanent resident that is applying on behalf of their immediate relative. And that is not available to any child who obtained their citizenship through the SIJS. So the special findings must be entered by a juvenile court, and juvenile court is defined here as a court located in the United States that has jurisdiction under state law to make judicial determinations about custody and care of juvenile. And you can see here a list of cases that this has been done and can be done in Nebraska. a quick overview of the SIJ process. The state court order will declare that the child is dependent on the court, or legally commit the child to under the custody of an agency or entity. And they will find what we just discussed: reunification of the child's parents is not due, child and parent is not viable to abuse, abandonment, or neglect, and it would not be in their child's best interest to be returned to the home country. And then after that, the process with immigration authorities begins, and they file what's called the I-360, requesting SIJS status. In general, these prior to 2018, these were very rarely denied, because there is it's not a discretionary application. It's if you have a special finding and you are eligible under those eligibility requirements we just discussed, then you are a special immigrant juvenile. That's changed in recent years, but it's still a very high level of approvals of I-360s. A child who, the child then files an application to become a lawful permanent resident, known as the I-485, and that in the accompanying requirements with that form. And then they become a lawful permanent resident. And then after 5 years of lawful permanent residency, they can apply to become a US citizen. Here I just make a note of the interconnectedness with state law and federal law. You cannot apply for SIJS without that predicate state court order. And it's important to make it clear to state courts that they're not making immigration decisions when they have this predicate order findings, that they are making factual findings about the best interest of the child, and that the best interest of the child controls in these cases. That's a little bit of the history of SIJS and the work that Immigrant Legal Center and Nebraska Appleseed did in order to help SIJS in Nebraska. And then I will give these 3 cases here as citations for special immigrant juvenile status cases. Here, the main takeaways are that the courts that have made initial child custody determinations do have jurisdiction in SIJS cases. That's actually coming up into practice right now with a few of my clients. And I would also, the second takeaway there, that SIJ status purposes has long been accepted by the Nebraska courts. And this is a great citation for convincing your judge as to why these findings can be made. And yeah, that's it. So what does this mean to you? Who can request the findings? Any party to the case or court on its own motion. The standard here is sufficient evidence. If the sufficient evidence is shown, then the court shall issue an order containing such findings when one of the parties requests it. In any juvenile court, as we just discussed, so custody, paternity, guardianship, and importantly, 3A and 3B cases. As it says there, when during a review hearing, or there's also been motions filed outside of review hearings. I'm going to skip over other considerations for the purposes of time. And here I will just note that there's a lot of ways to meet the sufficient evidence standard. Generally, it's through testimony. And in my practice, it's mostly through testimony of the individuals who have the information about the case, whether that be DHHS officials, St. Francis caseworkers, and or the parties themselves. I will make a note that there are some great databases at the State Department for country conditions. Generally, testimony from the individuals in the party are sufficient for for the purposes of SIJS predicate findings and determining best interest of returning to the country and the conditions of that country. However, there are some State Department documents that are really helpful in this matter as well. one note I would make here is the service to parents. A lot of this, in most of these cases, one of the parents or both of the parents are outside of the state, outside of the country, or are unable to be found. In general, this can be cured with service by publication. It does make a note down there. Don't forget to the affidavit of mailing and due diligence requirement in the civil cases for publication. And I would also say that if there is an address, any address that anyone can, find through whatever means, then that's also extremely helpful. Some other options are U visas. For U visas, you have to be a victim of a crime and suffer substantial physical and mental abuse, possess information about that crime, and be helping authorities or have helped authorities. This includes the cooperation of the police that convicted the crime, or that investigated the crime. And that's all I'll say about U visa for the purposes of time. These are a list of the qualifying criminal activities for U visas. But it is something to note that if your client has discussed being involved in a crime or being involved or having witnessed a crime, to refer to immigration attorneys and for U visa purposes. T visas are trafficking visas. You can see the following conditions there. Be in the United States, victim of severe form of trafficking, and again, comply with reasonable requests or assistance in investigation or prosecution of the trafficking, and then the showing of extreme hardship involving unusual and severe harm upon removal from the United States. Again, this is very fact specific. As well as the violence against women self-petitions related to an SIJS petition. Even though the name indicates it is only for women, it is actually available to spouses, children, and parents of US citizens. And this is generally when they have been victims of violence, domestic violence most generally. Also, I will just briefly go over DACA because due to recent litigation, the federal government is not allowing initial DACA applications, only renewals of DACA. So this would only apply if the youth has already obtained DACA. And then asylee and refugees. This is the definition of asylee and refugees, as you can see here. And asylees do, I think, is important for us to know for working with youth, because there are a lot of youth who came to the border to request asylum. But once again, asylum is an extremely complicated area of law, so I would suggest reference to an immigration attorney if your youth indicates that they are seeking asylum. This is derivative status, talking about how obtaining asylee or refugee status can be helpful to the rest of your family. And then there are family-based immigration options if there are US citizens or legal permanent residents in their family that are able and willing to apply for the youth. Immediate relatives are spouse, parents, or unmarried children of US citizens. And visas are available immediately for those who make these petitions. Preference categories are unmarried sons and daughters of US citizens, spouses and children of permanent residents, unmarried sons and daughters of permanent residents, married sons and daughters of US citizens, and brothers and sisters of US citizens. There is quite a bit of wait time for visas in these preference categories, as you can see here. As you can see in the F1 category, they're still processing applications from 2014, and in Mexico's case, 1999 and 2012. The wait times are pretty egregious in a lot of these categories, and generally not the best option available, but sometimes only the option available for immigrants. Again, I'm plugging NELA. This is the best way to get on the wait list for Immigrant Legal Center services. And here is our contact page once again. I will just say reminders for youth clients: don't work without authorization, try not to get in trouble, and consult immigration attorneys. I think getting an immigration attorney's opinion on any youth involved in the juvenile justice system is really important, and you should contact Immigrant Legal Center for that. Here is a handout that I'll try to disperse however we can. This is just our little one-pager in both English and Spanish about advice for minor clients and things that they should avoid. Sorry, I did go long as I thought I would, but if anyone has any questions, I'd be happy to answer them. It looks like we have a couple.
Yeah, there are a couple in the chat.
The child files. Surely there's someone who is filing for the best interest in the child. So yeah, generally I am talking about the legal representative. I use the child files as just an indication that the immigrant is filing, but as I said, a lot of immigrants are unrepresented in immigration proceedings and immigration court. Obviously, we are the ones at ILC that are filing on their behalf, but it would be a legal representative generally, or there are some really great advocates at churches and other community organizations that will try and do some of this work on behalf of them, but I can't make it I cannot make the point any more fine that you should be consulting immigration attorneys at any point possible. U visas are still being accepted. Generally, I think maybe what this question would be getting at is that it's kind of hard to involve Nebraska police in U visas and getting the requirements for U visas, but U visas are still being accepted. U visa wait times processing times are very, very long, and that might be what is indicated there. Is there any financial assistance for filing? Yeah, for filing immigration forms, there is a fee waiver form available. One great thing about the SIJS process and the I-360 is that there is no fee to file the I-360, but there is a fee to file the I-485, which is the application to adjust status. For approved I-360 SIJS applicants and applicants who might be applying for the I-360 and the I-485 at the same time, there is no fee required, and there is there's a portion of the fee waiver form that states that in the instructions. So if you go to it's the I-912 is the fee waiver form, and in the instructions, which is a separate document from the form itself provided by USCIS, the instructions state that an I-360 petitioner, is not required to pay the fee. So just highlight that for the immigration officer, and that's great. What documents are required for work authorization? So generally, the form that's used for work authorization is the I-765. However, you can apply for work authorization without status of some kind. So if you have a youth that has no status, then they will not be able to just apply to just make the application of the I-765. In general, that's not in their best interest, because if they were not otherwise on the radar of immigration, that would put them on the radar of immigration, and just generally not the greatest idea. Are we currently accepting clients? We're always accepting clients. Like I said, there is a wait list, but generally the wait list has been moving a little bit more quickly in the past few months. So yeah, always call NELA and direct your clients to call NELA and get on our wait list. Yeah, I don't see any other questions. Anyone else have questions at all?
Yep, I don't
Alright,
see any other, oh wait, there is one more question in there, one more. What about US residents if they have a marijuana or MIP DUI? Do they get
So
the residency
for-
taken away?
For US citizens, once you become a US citizen, either once you obtain the US citizen status, you can't have it taken away. You have all the rights and opportunities that a US citizen by birth would have. For legal permanent residence, this is a more complicated question. If you are a legal permanent resident and you get a marijuana conviction, or an MIP, or I would say marijuana more specifically because that's subject to the controlled substance grounds. The MIP and DUI speak more towards a different ground that's not very specific about drinking as there is specific grounds for drugs. If you are an LPR, a legal permanent resident, and you are subject to controlled substance conviction, then you are not deportable, but you are inadmissible. So what that means is that they're legally allowed to stay in the United States. However, if they leave the United States and they attempt to re-enter the United States, they will likely be stopped from entering the United States and returned to or just not allowed to enter. So generally, we advise that you do not leave the United States if you are an LPR with a conviction under the controlled substance grounds. How about a person with just a work permit? So generally, if you have a work, it depends on where you are in the process, I would say is the answer to that question. So if you have a work permit, you are going to be at some point along the process, whether that's having just been approved and still having to adjust status. So generally there is an approval of a petition, and then you have to adjust your status from unlawful to legal permanent resident. And in general, the I-485 is that form to do that. And that's where you'll run into the issues with any conviction or any crime, because that's a form that asks you whether you've committed any crime. And that's generally where you would come into issue with it. It's not gonna take away your work permit, but it will have issues with adjustment, and you might not be able to adjust status and become a legal permanent resident on that ground of that conviction.
We do have one last question there. We've got about 2 minutes left, so it'll probably be the last one. If a child participates in gang activity, are they inadmissible?
Yes, so that is a really important ground that I'm glad that you did bring up. Gang activity is a ground of inadmissibility, and it has been enforced more so since 2018 under the Trump administration, with their focus on gangs and specifically South American gangs. So it is a ground of inadmissibility. It's also a very highly problematic when talking about those discretionary decisions made at the immigration level. Generally, any indication of gang involvement, sometimes with no indication of gang involvement and just kind of a hunch on the part of the immigration officer, it can become a problem. So I would say that generally what you're going to want to, I think general practical advice when it comes to any issues with gangs and gang involvement is that you get all the information possible from the youth, and you make sure that you have every fact about gang involvement and whether the gang involvement was coerced in some way, whether they were under threat from them or a family member to be involved in a gang. That's generally at the discretionary level, I think is still an issue that the immigration officer gets to determine whether that duress or that issue, that threat was enough to justify your involvement in the gang. So gang affiliation and gang activity, any interaction with a gang, being the girlfriend of a gang member is really, really problematic. I appreciate you bringing that up, Rosa.
All right, we are at the end of our session. Thank you so much, Anne.
Yeah.
Appreciate it. Thank you everyone for attending.
Yeah, thanks
next-
everyone.
Our next lunch and learn will be on November 12th, and information will be coming out about that this afternoon. Thanks, everyone.